Hello, everybody. Welcome to the Humanities Forum. If, like Dr. Keating, you're still looking for a seat, let that be a lesson for you. On time is 5 minutes early, right? No, it's great to see you all here today. I want to welcome you to the forum, which happens most Fridays in this very room at this very time. And my name is Ian Bernhoft, and I direct the forum, which is, as you'll realize, if this is your first time, you'll figure out what's going on. But it's a time for you to reflect on bigger questions, broaden your horizons, encounter new ideas, new scholarship from speakers who come from around the country and indeed around the world, and to deepen your appreciation of the humanities. Now, today's talk, I believe, is going to touch on obligations at some point, like what are our responsibilities? And so you have a few as attendees at this. And the first one is going to break your heart, but I got to say it, which is you're going to take those beautiful laptops and slowly snap them shut so that you can actually pay attention to what's happening in the room. Your second obligation is that if you've been to one before, you'll know that we have a Q&A after the talk, which runs for about 20 minutes, and a student has to ask the first question. So get those wheels turning now about what questions you want to ask. So they'll be popping up. And then your final obligation, we don't enforce this one as regularly, but I would if I could, is to, when we get done, march down the hall and hit the reception in the Fiandela Great Room. There's always some tasty treats down there, and it's a chance to meet people, decompress with your friends, all that kind of thing. Okay, before I hand over the microphone, I got to tell you one more thing, which is this lecture today, this Humanities Forum, is made possible by the generosity of two different institutions or people. So on the first hand, it is the St. Albert the Great Lecture in the Science and the Humanities, which is in honor of Louis Verza. So this is an endowed lecture we have every year, named after St. Albert, who is the saint who sort of best encapsulates the light of reason and the light of faith working together. And so it always touches on the intersection between science and the humanities, between questions of, what you're here today, what we ought to do and what's right, and also science and what's going on there. So that's one sponsor. The other sponsor is the School of Nursing and Health Sciences. So we're very appreciative of their support of this event as well. Okay, I'm going to relinquish this microphone. I'm going to pass it over to Professor Father Brophy, who's coming to us from the Political Science Department, and he will introduce today's speaker.
Thank you, Ian. Carter Snead is the Charles E. Rice Professor of Law and Director of the DeNicola Center for Ethics and Culture at the University of Notre Dame. An alumnus of St. John's College and Georgetown University Law Center, Professor Snead has taught law at Notre Dame since 2005. Professor Snead is one of the world's leading experts on public bioethics. He is the author of What It Means to Be Human, The Case for the Body and Public Bioethics, published by Harvard University Press, and named by the Wall Street Journal as one of the 10 best books of 2020. As director of the DeNicola Center for Ethics and Culture, Professor Snead has been a stalwart promoter of the Catholic moral and intellectual tradition, and he's been a mentor and a help to many students, faculty, and professionals, many of whom are present in this audience. And since we're having a talk on the body, I am obligated to say that he is a very excellent cook. It is my pleasure to welcome distinguished professor and my friend, Carter Snead, to Providence College.
Thank you so much, Father Justin, and thank all of you for coming to this lecture on Friday afternoon. Wow. It's a great pleasure to join. This is my first time ever to Providence College, and it's so exciting because I have so many wonderful friends who are here and students that I've known since they were little who are here. And I'd also like to thank Justin for reading my introduction exactly the way my mother wrote it for him to read this evening. And as you may have noticed, the topic of my remarks today very closely track the themes of the book that he alluded to, which doesn't mean you shouldn't purchase the book, especially with Thanksgiving and Christmas coming up. It's a fantastic gift for anyone in the family. You should buy multiple copies of it, even now. And it's also a Spanish translation, so if you have Spanish-speaking friends, you can buy them that as well. So the talk today, basically I have two sorts of propositions that I would like to make to you, one of which is a kind of methodological point, and the other one is a substantive point. The method argument is about how to think about law in general, but specifically how to think about a particular area of the law called public bioethics. Public bioethics is the governance of science, medicine, and biotechnology in the name of ethical goods. It is the point at which law comes into contact and self-governance comes into contact with the ethical questions arising from biomedical science and biotechnology. It's not simply a field of intellectual inquiry, but in fact it's a branch, as I said earlier, of law, of concrete law. So actions of the state, sometimes supported with coercion, sometimes through the mechanism of incentives and inducements, but meant to shape human behavior, to reflect certain kinds of norms, to teach certain kinds of norms in the name of ethical goods in the context of biomedical science, biotechnology. So the argument I want to make is the best way to understand the issues of public bioethics are through what I describe as an anthropological inquiry. Now that sounds highfalutin or super technical. It's not. The phrase inductive anthropological analysis simply means it's inductive in the sense you take the law as you find it, right? You look at the judicial opinion, you look at the statute, you look at the case law or the regulatory scheme or the scheme of self-regulation that's permitted by gaps in the law, and so that's inductive in the sense that you take the legal authorities as you find them. You're not imposing a kind of intellectual structure ab initio on what you're understanding. You're sort of just taking it as it comes. And it's anthropological in the sense that the question you're asking is what vision of the person, of human identity and human flourishing, is underneath all of these legal principles, these legal doctrines and legal rules. What does the law assume about persons, and how does the law constructed accordingly? And I'll make a case for you, as in the course of my remarks, as to why that's really the fundamental question to ask, really about any legal scheme, but especially about the law of public bioethics. So I'm going to make an argument in the first instance for a method that I think is the richest and deepest method for understanding this distinctive and vexed field of law and policy. The second argument I'm going to make to you is when you do that, when you apply that anthropological inquiry to particular vital conflicts of American public bioethics, and there probably won't be time to get into the concrete areas of public bioethics that I take up in the book, and I'll say more about that in a second, but we'll certainly have time in the question period to make these, what may seem like abstract arguments, more concrete. The argument I make is when you ask those questions, when you look at the law connected to, for example, end-of-life decision-making, you look at the law relating to how end-of-life decisions are made in the clinical context, or if you look at the legal schemes or the debates and discourse around assisted suicide, for example, and if you ask the question of what undergirds the legal principles and doctrines that are active in that space, what comes to the surface is a vision of the person that is true in some important ways, but deeply incomplete and impoverished, and therefore not a suitable anthropological foundation for the legal doctrines and policies that rest on top of it. And the vision of person, individual, of identity, human identity and flourishing that I'm referring to very closely tracks what sociologist Robert Bellah and philosopher Charles Taylor have called expressive individualism. It's a particular understanding of who we are and what our flourishing consists in that I'll elaborate on as my remarks proceed. But this vision of expressive individualism is problematic, generally speaking, but it's especially problematic when it becomes the anthropological foundation for the laws and public policies relating to bioethics. And the principal reason for that is because it is a vision of human identity and flourishing that can't make sense of a fundamental aspect of who we are, namely our embodiment. And what I mean by that is the fact that you and I are living bodies. We encounter ourselves, we encounter one another, we encounter the world around us as living bodies. And by virtue of the fact that we are dynamic, psychosomatic unities of mind and body, and not merely disembodied wills, but in fact, it's essential to our embodiment is essential to our identity, there are certain kinds of consequences that follow from that that expressive individualism can't give an account of. Our vulnerability, our subjection to natural limits, our reciprocal indebtedness to one another owing to our vulnerability. Expressive individualism, as for reasons that I'll explain, can't make sense of those essential aspects of what it means to be human. And those aspects of our humanity, those essential aspects of our humanity, play a very significant role in the questions in and around public bioethics. Okay, so to make this case, the structure of my remarks will proceed as follows. First of all, I'm going to say a few more words about public bioethics, give you an example, a couple examples of which legal issues are we talking about. And just to be clear, when I'm talking about public bioethics and the anthropological assumptions or the assumptions about who we are and what our flourishing consists in, I'm talking about the assumptions and presuppositions of the law. I'm not talking about our presuppositions or how we think about ourselves when we act and make decisions, and do we think of ourselves as individuated wills, do we think of each other as bodies, embodied souls living in community. I'm not talking about what we think about. What I'm talking about are the presuppositions of the law and how those presuppositions measure up compared to the lived reality of human existence. Okay? But I'll say first a few words about public bioethics. I'll give a little bit I'll give some additional argumentation around why this anthropological question is the right question to ask. It might seem strange. Like if I'm trying to understand the legal doctrine, the jurisprudence of abortion of Roe v. Wade and Planned Parenthood versus Casey, why am I asking questions about human identity and human flourishing? Or if I'm trying to understand the laws and the absence of law in the domain of assisted reproductive technologies, why am I asking questions about what it means to be and flourish a human being? Shouldn't I just start with the black letter doctrine and ask what it's trying to do and what's not trying to do? Isn't that a sufficient way to understand the law? And the argument I'm making is no, you have to go more deeply into the question, and I'll say a few more words about why that is. I'll focus on this, I'd say, incomplete and problematic anthropology of expressive individualism. I'll spell out exactly what it entails, fill out for you a little bit more what that vision of human identity and flourishing looks like. And then I'll talk about the corrective, the remedy for an incomplete set of premises about who we are and what we need by focusing again on the question of embodiment. And to borrow a phrase from my colleague Alistair McIntyre, after a fashion, I'm going to argue for remembering the body, how to think about the body and thinking about who persons are in building our laws and public policies, and alongside the goods and practices and virtues that are essential for building up the structures that are necessary for human flourishing among a community of embodied persons. Okay, so very briefly, what is public bioethics? I've given you a definition, right? I've said it is the governance of science, medicine, and biotechnology in the name of ethical goods. That's the definition of what public bioethics is. But what is it about? If you drill a little bit more deeply, what is it about? Well, it's fundamentally concerned with human vulnerability, human dependence, frailty, and finitude. It's about procreation and pregnancy and babies and wasting illnesses and devastating injuries. Desperate enrollees in clinical trials, for example, fearful patients, the disabled, the elderly, the dying, and the dead. Put another way, public bioethics is most deeply about the meaning and consequences of human embodiment. The fact that we experience ourselves, one another, and the world around us in, and more properly said, as living bodies. You will never, in this life, encounter a person who is not embodied. Right? The body is the locus of personal presence. We are our bodies, okay? Now, American public bioethics is a field of inquiry, and I won't go too deeply into these examples, is essentially a reactive form of governance, meaning usually what happens is there's a scandal or a high-profile incident, and then the law responds to that high-profile incident in a way that means to react to it, to control whatever damage has occurred, and then to erect barriers in the future to the repetition of those kinds of deep problems. And in the book, I argue that the way to understand the birth of American public bioethics is through the lens of three signal events represented by these images here. On the left, you see Dr. Henry Beecher. He was an anesthesiologist from Harvard, not far from here, and he was really interested in the questions around the Nuremberg trials following World War II involving the so-called Nazi doctors who conducted a series of horrific and exploitative and ultimately fatal experiments on the people that were being held in concentration camps. Okay, so these horrible experiments took place. The doctors, after the war, were put on trial. Many of them were convicted. Some of them were executed. And at the trial, they argued, first of all, they argued that we didn't break any laws. Second of all, they argued that these folks that we conducted these experiments on were going to die anyway, and that wasn't our choice, and we didn't put them in the concentration camps. We didn't mark them for death in this way. We were simply trying to salvage something positive out of this otherwise tragic situation. And then thirdly, they said, by the way, you, United States, who are accusing us, don't actually have in your own laws a code of ethics for the medical and clinical context and the research involving human subjects either. And on that last point, they were correct. There was, in fact, not an ethics code yet, and in fact, the first such code of the American Medical Association was adopted in the late 1940s, immediately in response to that argument. Okay? But Henry Beecher said, well, and I should say, none of the arguments, defensive arguments they made were accepted. One obvious response to their arguments was like, well, you weren't merely passive observers. You actually took custody of these people who were being exploited already and then made their exploitation the object of your research and used their situation, their tragic situation, as a license to exploit them further in the name of your own projects. And that's not being merely passive. That is something that is active and something that is blameworthy, and you're going to be held responsible as a result. But Beecher was intrigued by this trial, and he was read into a bunch of classified documents and started to ask questions about, well, what do we do in the United States to protect human subjects of experimentation? Human subjects of experimentation are uniquely vulnerable because the object of research involving human subjects is not the treatment of the subject. It is the development and acquisition of generalizable knowledge. It's to learn something important about a particular question, usually, and most commonly the approval of a drug or a medical device, to see if something works, is it safe, is it efficacious, and then to do more elaborate studies and see how it can be titrated and analyzed and applied in ways that are clinically beneficial. But technically speaking, if you do an experiment on human subjects and you find out that a drug that you're testing doesn't work, or even if it's dangerous, that's actually a successful experiment in the sense that you're producing generalizable knowledge. And you're effectively using these human subjects in an instrumental way. And so how do you figure out how to transform that relationship of potential exploitation into one of ethically defensible collaboration? And the answer is usually to try to secure something like informed consent from these individuals. But even that itself is complicated, and we could talk about that all night long, but that's just, so Beecher was worried about that. He's like, how are we doing in the United States? We saw what the Nazis did. How are we doing? And he conducted a study of 22 different research protocols in the United States being undertaken by the most eminent research institutions in the world, at Harvard and by the US government, the Public Health Service, et cetera, and found, to his chagrin, that there were 22 instances of terrible examples of exploitation and abuse of human subjects by these august institutions, and the results were published in peer-reviewed journals which knew about the process by which these experiments were conducted. And in all but 2 of them, informed consent was not even attempted to be secured, and in the 2 remaining ones, it was only inadequately sought. But one of the things that he found, for example, is that there were these children with intellectual disabilities at a state institution called Willowbrook on Staten Island, where the children were deliberately infected with hepatitis. He found at the New York Jewish Chronic Disease Hospital that there were patients that were deliberately injected with live cancer cells. There were instances involving enlisted servicemen and women who were subject to experiments without any authority to say yes or no or even know what was going on. And there were terrible results that followed. And he published his results in 1966 in the New England Journal of Medicine in a very modestly titled piece called Ethics in Clinical Research, revealing this, and it sent shockwaves throughout the American public. The other two examples follow a very similar pattern. In the middle, you see sharecroppers from Tuskegee, Alabama. And in Alabama, in the 1930s, federal researchers from the Public Health Service of the United States government traveled to Macon County, Alabama, which had one of the highest rates of syphilis of any community in America, to study the natural progress of syphilis untreated in this particular population. So they went down just to watch how the disease moves through people when it's not treated, okay? But they went down to Tuskegee, Alabama, to a community that was beset by poverty and racism and lack of education. And these sharecroppers were already in a very vulnerable situation. And the U.S. government went into that community, didn't tell them what they were doing or what they were testing for. They said something like, we're going to test you for bad blood, and we're going to give you money for lunch and transportation and maybe funeral expenses, and we're going to make you draw blood. We're going to make you get spinal taps, which are extraordinarily invasive and painful procedures. And they did this to 600 people in this community, never once telling them what it was that they were doing, actively deceiving them. And in the middle of the 1940s, this was supposed to be a very short project. It went on for 40 years, okay? And in Tuskegee, Alabama, they in the middle of the 40s, antibiotics became standard of care for treating syphilis. And they didn't give anybody antibiotics. And they didn't tell anybody about antibiotics. And there's good evidence to suggest that they actually colluded with the local health services to prevent anyone in that community from learning about this particular medicine. And when they were confronted about this in 1973, when it came to light, when a low-level researcher in the study section of the Public Health Service raised the issue, saying, "What are we doing? This is insane." And he was ignored. And he finally went to the Washington Daily News. And in 1972, it was reported, human guinea pigs, syphilis patients die untreated. The response by the Public Health Service was, we didn't create this terrible situation of poverty and racism and exploitation. We simply came down into this situation and tried to salvage something good out of the tragedy and gather information. The argument was structurally identical to the argument of the Nazi doctors at Nuremberg. We weren't doing anything worse. We weren't making the situation worse. If we hadn't gone there, everything would have gone exactly as it had gone. We just didn't help, right? And just as in Nuremberg, those arguments were roundly rejected. And they said, no, that's a shame and a scandal. And there was a $10 million settlement and apologies issued by the U.S. president. But nevertheless, sent shockwaves through the U.S. community. Now the third, and a lot of people have heard of Beecher, a lot of people have heard of Tuskegee. Not a lot of people have heard about the third scandal that occurred roughly at the same time, in which doctors in the United States would travel to Scandinavia, and the record is unclear as to whether they were federally funded or not. They would travel to Scandinavia where abortions were performed by a process called hysterotomy, which is basically a C-section and a live delivery of a baby, and then just letting the baby die once the baby has been delivered. And this would be done at variable stages of gestation, usually prior to around 22 weeks, but at the same time, the purpose of the procedure was to terminate the pregnancy and end the life of the baby, who at that point was a newborn baby, right? We're not talking about an in utero human being or what might be called a fetus. We're talking about a newborn baby, sometimes attached to his or her mother by their umbilical cord still. And these doctors would go to Scandinavia and perform research experiments on the newborn, imminently dying babies in ways that would extend their life briefly, but then cause their death and inflict additional suffering. And the arguments they made was, well, look, this baby was marked for death by virtue of the abortion. We didn't choose the abortion. The abortion wasn't done for the sake of research. It was done for a different purpose. We're just coming in, and we're taking a tragic situation, and we're salvaging something positive from it by gathering information about how these devices work, how these drugs work, et cetera, how these radio-labeled microspheres move inside the circulatory system before the baby expires. And that also, not surprisingly, published in the Washington Post around the same time, April 1973, sent, again, shockwaves around the country. People were mortified that this was happening. They were worried that the federal government was paying for it. And in fact, Maria Shriver, daughter of Eunice Shriver, Eunice Shriver, the sister of John F. Kennedy, Robert F. Kennedy, and Edward Kennedy, found out about it, and she organized a protest at her school. Maria Shriver later became a journalist and the First Lady of California. She was, as a high school student, brought 200 Catholic high school kids across the street, across the Rockville Pike to NIH to protest. And more importantly, her uncle, Senator Edward Kennedy convened hearings, not just on that issue, but on the issues relating to Tuskegee, the issues relating to the research involving human subjects, research on imminently dying neonates or newborns in Scandinavia, possibly federally funded, and more generally, a suite of bioethical questions that had been on the mind of the U.S. Congress since the late 1960s when Walter Mondale had convened a similar series of hearings, but without it culminating in anything significant. But in this case, and this is what I mean by public bioethics being a reactive form of governance. Something happens, a scandal happens, and some branch of government reacts to it. And in this case, the culmination of that reaction after a series of hearings where basically you have witnesses from these different contexts come and give testimony and argumentation and statements made by the senators and so on. And it culminated in the passage of a federal statute called the National Research Act, which was the first federal statute relating to bioethics in American history. And that was in the early 1970s, passed in 1974. And it did several things. It put in place a statutory scheme, which then later gave rise to a regulatory scheme for protections for human subjects involved in clinical research. But it also created the first National Bioethics Commission. The first National Bioethics, and it charged that commission with the authority to articulate the fundamental principles of bioethics that would govern all these different spheres, and required the Secretary of Health, Education, and Welfare, which we now call Health and Human Services, to implement those recommendations or explain why he or she thought they shouldn't be implemented. So it was a very powerful body. I actually served as general counsel on the President's Council on Bioethics from 2002 to 2005, which was a successor entity to this body, although ours was created by executive order, not federal statute. But this set in motion, this marks the beginning of the law, in my view, coming into contact in the deep way with these public bioethical questions. And in the context in which these issues arose, it shows some unique features of American public bioethics. How complicated it is. It involves not just hyper-technical questions in terms of biomedical science, but it also involves complicated moral and ethical questions because they frequently come in the form of integrated goods and risks, goods and harms, good intentions, bad results, a temptation to exploit vulnerable communities for the sake of what some perceive to be the greater good. They deal with contested questions, matters of deep disagreement about the nature, meaning, and consequences of birth, life, death, procreation, parenthood, and so on, including issues of race and poverty and illness and scientific freedom, autonomy, dignity, etc. Public bioethics squarely and unavoidably poses the question of who are we and what do we owe to one another? And they frequently involve what I call vital conflicts sort of zero-sum matters of life and death, questions about the contours and boundaries of the human community. Who counts as one of us? Whose good counts as part of the common good? And who decides? And then finally, what was shown by all of these examples, and especially if you look at the National Research Act itself, the solution that's frequently set forth to deal with these kind of scandals is, well, we need to enhance autonomy. We need to construct rules and put in place policies that allow people to exercise their freedom of choice and to choose whether to participate in these research protocols or to choose whether to subsidize different kinds of controversial areas of research and so on. We need, and informed consent is the most pristine example of the good of autonomy operationalized in a kind of regulatory principle. Informed consent was frequently the answer. But what you notice also from these examples is that informed consent and a refuge in autonomy, which seems good because everybody can agree on freedom, at least, and everybody can agree that we should be allowed to make decisions on our own behalf, that's not a tool that's valuable for a lot of the most vulnerable populations, especially the ones that were involved in those three examples, right? The intellectually disabled children at Willowbrook would have received no benefit from robust informed consent rules because they didn't have the cognitive capacity to make free decisions about whether or not they wanted to participate in those activities, okay? The same could be said of prisoners whose autonomy is dramatically reduced by circumstance. The same could be said of enlisted men and women in the services who are subject to a strict chain of command. The same was certainly said of the patient suffering from dementia in the New York Chronic Disease Hospital. You could say the same about, you obviously say the same about the newborn babies in Scandinavia. Informed consent is not an intelligible solution to that problem if what you're concerned about is the exploitation of those individuals. And you could even argue, make the case that sometimes socioeconomic circumstances, systemic racism, rampant poverty, suppresses the capacity for freedom in ways that make the offer of freedom an unintelligible solution to those kinds of problems, when in fact what needs to be done is to step in and protect those communities from exploitation. Okay? Now, issues in public bioethics involve, I've already mentioned some of them, protection of human subjects of research, embryo and fetal research. The three topics that I took up in the book are the law of assisted reproductive technologies, the law of abortion, and the law of end-of-life decision-making and assisted suicide and euthanasia. But it is a broad area covering an awful lot of regulatory terrain. So, that's public bioethics. That's how it emerged in the United States. Why do I think that the deepest point of entry and the most fruitful and rich way of engaging these questions is through these, what I'm calling anthropological questions? Why do we care what the law's presuppositions about human identity and human flourishing are? Well, there are a couple things. First of all, I want to say something important about law generally that may be surprising to some of you, but you frequently hear, well, law and morality should be kept separate, law and justice, principles of justice should be kept separate, law should just be sort of the bare minimum that we can all agree to, overlapping consensus, and there should be maximal swaths of human activity that is free from any legal intervention. Well, I'm here to tell you that the notion of law shorn of moral principles or principles of justice is itself unintelligible. What law is, at the end of the day, what law is a human institution that aims to promote certain kinds of goods or to protect against, avoid, or even punish certain kinds of harms. Law is irreducibly normative. Law means to do something which depends on prior conceptions of good and bad, right? Or useful and not useful. But even more deeply, law requires us to have agreement about, or it requires an operative principle of justice and equality and freedom and fairness and due process. There's all kinds of things that we have to settle before we can begin to build legal doctrines and regulations and principles that are irreducibly normative. Now, to say that law always integrates morality and principles of justice is not to say that every moral or ethical question or even question of justice requires a legal framework around it. Not every bad thing needs to be forbidden by the law, and not every good thing needs to be encouraged or promoted by the law, but everything that the law does touch is infused with this prior judgment about morality, ethics, justice, freedom, equality, etc. And because law is so irreducibly normative, it has two interesting and important features for our conversation. One, it reflects the goods that a people hold dear and the harms that they seek to avoid. If you want to know what a given community or nation or polity cares about, you could do well to look at what the law says in that community. You can learn a lot about what goods those folks seek to promote, what harms they want to avoid or punish. It's Oliver Wendell Holmes, who is not generally a person I cite for bioethical wisdom, and we can talk about why that is in a little bit if you want to. But he was right when he said that law is the witness and external deposit of our moral life. And as a result, it doesn't merely reflect what a particular community believes or cares about. It actually also has a pedagogical dimension. It shapes what people think about goods and harms, for better or worse. People take their moral bearings, their ethical bearings, their understanding of justice and fairness and equality from what the law already provides and what the law already suggests. Law is the omnipresent teacher in this way. So, what does that have to do with anthropology? Not in the sense of the academic discipline, but in the sense of what it means to be a human being. Well, one of my favorite novelists, Walker Percy, said correctly that everyone has an anthropology. Everyone operates according to assumptions about who we are and what our flourishing consists in. There's no not having one. And if you say that you don't have one, all you're saying is that your anthropology is implicit. And that's true of the law as well. Now, I think a good, concise definition of the purpose of law is that law is about and for the protection and flourishing of persons. Okay? That's what law is for. It's for the protection and to promote the flourishing of persons. And therefore, it unavoidably rests on usually undeclared conceptions of human identity. You have to have assumptions about what persons are if the goal is to protect persons and promote their flourishing. You have to have a sense of what their flourishing consists in. And because that anthropological question has to be settled before you begin to build the law, the deepest and richest understanding is necessarily anthropological. You ask the question, who and what does the law assume persons to be at bottom? Because if you get that question wrong, everything else is going to be wrong. If you're wrong about what person, and again, is the question of anthropology contested and vexed and people bitterly disagree? Yes, of course. Absolutely they do. But I'm not suggesting that it's easy or there's uniform views about what persons are, what human flourishing is. Quite the contrary. But what I am saying is you can't build law unless you have an operative principle of answer to that question. Otherwise, it's arbitrary and capricious and unintelligible. Okay? So there's a particular set of premises about human flourishing and identity that is present in public bioethics that causes certain areas of the law to go wrong, in my view. And that is, I've already said, expressive individualism. I'm not going to give you the intellectual genealogy of expressive individualism or the literary reflections of expressive individualism. There's a lot of interesting stuff. I'll just summarize briefly what it says. And that is, the person in the anthropology of expressive individualism is understood to be an isolated, unencumbered, atomized, to borrow a phrase from Charles Taylor, individual self. This fundamental unit of human reality is the individual, shorn of all constitutive attachments, abstracted from any human context or tradition or family or relationship or community. It is an abstraction. It's the idea of the atomized individual who is defined by the operation of his or her will. That is, you are your will. You are the cognitive functions that amount to the exercise of your will. And your body is an instrumental tool to help you to realize the products of your will. What defines you is your capacity to choose in your individual sense, right? You are defined as a chooser or a consumer, and human flourishing consists in sort of thinking deeply about the interior sense, your own interior sensibilities, to examine and interrogate the depths of your interior sensibilities to come up with a kind of authentic, original, maybe transgressive truth that you then use to first express and then configure your life plan in pursuit of the plans that emerge from that kind of introspection. You are, to borrow a phrase from Michael Sandel, a self-originating source of valid claims. Nothing is morally authoritative except for the unique interior voice that you can discover and discern through this process of introspection. And then once you find your truth, you express your truth, and then you configure your life plan in pursuit of that original truth. Now, to borrow a phrase from philosophical locution, this is a profoundly anti-teleological idea, meaning, it sounds, again, very technical. All it means is this is a vision of human identity and flourishing where the world of external givens, the world of what the physical reality that you can observe around you is not a useful guide to action. It's not a useful guide to what you should do or what you should be. You are a blank slate, a tabula rasa. Did you ever wonder what a tabula rasa looked like? I did. I Googled it, and that's what it looks like right there. It's a blank slate. There are no natural givens that are observable or knowable from observation of this physical world that tell you what you should be or what you should do. The only authoritative voice is the interior voice, the inner voice. And just in the same way that there's no external morally authoritative reality to guide you in your actions and choices, there's also no such thing as an unchosen obligation. The only source of obligation for you is consent. The only source of obligation that you have, there's no one who can make a claim on you to say, please help me because we have a natural relationship. I'm your child, I'm your elderly parent. There's no natural relationship that gives rise to an unchosen obligation. The domain of obligation is strictly, or constitutive attachments, it's only a creature of consent. And as a result, personal relationships are instrumental and transactional. Now that doesn't mean that two people can't collaborate together for a shared goal, but the moment that shared goal is no longer shared, then that relationship sort of dissolves and comes apart, and that includes familial relationships. But people don't merely encounter one another as atomized individual wills seeking to collaborate. They frequently also encounter each other as adversaries that have to be overcome and overborne. So in some ways, the world of expressive individualism is a world of strife among atomized individual wills or minds. And the ethical in this framework is reduced to autonomy, to self-determination. Autonomy is the highest good to which all others are subordinated, and injustice is reconfigured as any constraint on your freedom to pursue the projects of your own choosing. That's what injustice is in this scheme, okay? And the role of government and social life, and this is where sort of public bioethics comes in, is to remove constraints, public constraints, private constraints, maybe even natural constraints, and otherwise provide the conditions for the assertion of the unencumbered individual self. Now, this is a very kind of sexy vision of what it means to be a person, right? It's the atomized individual bestriding his or her environment, imposing his will to try to find the unique path that you've discovered inside yourself, and maybe even in a transgressive way to challenge the mores of the time that require challenging. And there's some truth in that, right? We are free. We are individuated. That can be valuable. But the reason it fails as an anthropology for public bioethics is because it's not the whole truth about who we are. In fact, if you think about the arc of a human life, it begins in conditions of total dependency, right? Even before you're born. Conditions of total dependency on another person to support your very existence before and after you're born. And then gently, if everything goes as well as it could possibly go, you will begin, as you grow and get older and more mature, but continue to be in this supportive environment, you will find a gentle arc upwards towards the height of your powers, where you become independent, and you can express yourself, and you can impose your will. But then almost immediately, you begin to pivot downwards and back into a gentle, God-willing slope into total dependence again at the end of your life. So the problem of expressive individualism is one snapshot in your life story at the very peak of your powers, and it doesn't apply to everybody. Didn't apply to those kids at Willowbrook. Didn't apply to those sharecroppers in Tuskegee. Didn't apply to newborns in Scandinavia. Didn't apply to the people in the concentration camps at Nuremberg. Because those folks lived in conditions of deprivation that made it impossible for them to exercise their freedom of will and freedom of choice. So it's not just one moment in the lifespan that expressive individualism looks at. It's actually one moment in the snapshot of the most privileged and powerful among us in the human community. It's only a very small sliver of the human family that maybe can ever exercise the sort of agency that is necessary to realize the vision of expressive individualism. And everybody else is radically dependent at various moments, sometimes throughout their entire lives. And why is that? It's because expressive individualism only focuses on a cognitive account of what a human person is. It only focuses on your mental capacities for agency, choice, deliberative decision-making, the formulation of preferences, and the pursuit of those preferences. And that doesn't exhaust the explanation of what and who a person is. And that vision of the person is false and impoverished because it ultimately ignores the fact that we are embodied beings in time. As embodied beings in time, we are fragile, we are finite, we're dependent, and therefore we're reciprocally indebted to one another. Lived embodied reality is characterized by these weaknesses, right? Mutual dependence, vulnerability, natural limits. Alistair McIntyre says every person exists on a scale of disability. And what people need as embodied beings to survive and flourish is not the freedom of the unencumbered will alone, which can be valuable in a certain context, but it doesn't even come close to explaining the needs of humanity writ large. What people who are embodied beings in time and fragile and finite and dependent need are what McIntyre calls networks of uncalculated giving and graceful receiving. What you need to live is not radical freedom, although that's valuable in its own way. What you need are networks of people who are willing to make your good their good without counting the cost, without seeking anything in return. First of all, you need it for your basic survival. No one, including me, would be standing here right now if there weren't someone, probably your parents, who took your good to be primary in their goals and said, I'm going to make the goods of this individual my own good. I'm going to do everything I can to support the good and the flourishing of this individual because they are utterly dependent upon me. And if someone hadn't done that for us, we wouldn't be here right now. So you need it for your basic survival. But you also, I argue normatively, you need networks of uncalculated giving and graceful receiving composed of these people who will make your good their good without counting the cost, because that is what teaches you what it means to be and flourish as a human being. Put a different way, by virtue of our embodiment, what we are made for is not radical freedom. What we're made for is love and friendship. And we are most human when we are taking care of one another. And expressive individualism, as valuable as it is in the limited context in which it's true for some people, is it's unable to recognize these unchosen claims of the weak, including children, including the disabled, including the elderly. It ends up looking like what Bertrand Juvenel called a chartered libertarianism for the strong. It results in loneliness and dislocation and alienation. There are no constitutive relationships. Really, it all comes down to you, and no one can really know the interior of your soul in the way that you can. And it's death-haunted. Solzhenitsyn said, if you're the central point of the universe, your death constitutes the extinction of the entire universe at a stroke, and that's a terrifying proposition. And it results, as Bella found in his own social science studies and the book Habits of the Heart, it results in the erosion of social and familial ties. So how do we fix this problem? If we have legal areas that are built on this falsehood of expressive individualism, how can we reinfuse the doctrinal principles with a true and a full account of what it means to be and flourish as a human being? And the way we can do that is to begin by remembering the body. Think about the goods and practices and virtues for lived embodied reality. How do we construct, sustain, shore up these networks of uncalculated giving and graceful receiving? How do we become the kind of person who can make the good of another our own good without seeking anything in return? How can we cultivate our memory and moral imagination to see those who have claims on us who aren't part of our plans, who aren't part of our instrumental plan to succeed in the goals that we devise for ourselves, who derail our plans because these folks have a claim on us? And in the book, I argue that these networks are sustained by what McIntyre and others have called the virtues of acknowledged dependence. Okay, so this is some of this is drawn from McIntyre's own work, added and synthesized with some other projects as well. So the virtues of acknowledged dependence are the virtues first of uncalculated giving. This is what we have to practice to build up these networks of giving and receiving. One is just generosity, the virtue and practice of giving to the other in proportion to their need. Not because we're bargaining for valuable exchange or consideration. It's because the need itself dictates what we give. We give in proportion to need. Hospitality, welcoming the stranger because he or she is a stranger. The good of misericordia, that is, the good of taking on another person's suffering as if it were your own suffering. And then the virtues of graceful receiving. Principal among them, gratitude. Gratitude and acknowledgement that everything that we have ultimately is a gift. Everything that we have can be traced back to the generosity of others. That engenders a sense of humility and contributes to what Michael Sandel has called an ethic of giftedness. It sort of engenders an attitude towards the world that is not about rational mastery and manipulation and extraction and exploitation and control, not about how can I bend this to make it work for me, but rather how can I treat for example, how can I treat a child as a gift? My child is a gift and not a project, not a vessel into which I pour my own aspirations, but rather a gift. And the proper posture towards a gift is gratitude, right? Openness to the unbidden. Again, avoiding the attitudes of rational mastery and extraction and manipulation. When you have this sort of sense of gratitude and humility, and what comes with it is this notion of openness to the unbidden and tolerance of imperfection, right? The good of solidarity, understanding that we're all connected to one another and have obligations, chosen and unchosen to one another. The respect for the intrinsic equal dignity of every human being, every member of the human family. The virtue of truthfulness, right? And honesty. This plays out in dramatic ways in the context of human subjects protections, right? All of these virtues of graceful receiving and uncalculated giving can be understood through the original and Aristotelian sense of genuine friendship, making the good of another your own good, and focusing on those practices that take us outside of ourselves, that draw our gaze up from ourselves and out to around us to see those others, brothers and sisters who have claims on us, people who need things from us that aren't part of our plans, who derail our plans, and to hear those calls and to respond. And in the context, and the paradigm of this is the paradigm of parenthood, right? Parents don't take care of their children because they're seeking some benefit from taking care of their children. They take care of their children because it adheres in the natural relationship itself. That's an unchosen obligation. Children don't have to earn the right to be cared for by their parents. It's an unearned privilege. that children have in virtue of the natural relationship itself. But even outside the concept of parenthood, zooming out to other sort of communal relationships, communities, what Bella calls communities of memory, are sites where we can develop and practice these goods of uncalculated giving and graceful receiving. So I'll stop there, and we can answer questions. We can make it more concrete by applying it to more concrete areas of the law. But I think in principle what I've done now is to give you sort of the problem, the context, public bioethics, and what I take to be the beginnings of a solution, namely remembering the body and developing these goods and practices to shore up these networks of giving and receiving that are essential for the flourishing of embodied beings in time. So thank you very much for your patience, and you can have questions.
Who's got the first question?
There's a student back there, it looks like.
Hi, I'm May Abreu. Thank you for your talk today.
Where are you from?
I'm from Farmington, Connecticut.
Oh, okay, great. And your name is May?
May
And your last name is Bruno?
Abreu.
Abreu, sorry. Yep, misheard you.
So my question is, it's kind of like two questions
Sure.
in one. Do you think that expressive individualism is more accepted in American society than the rest of the world? And how do you think that has negatively impacted our society or our morals? And do you think it has created more of a bubble over American society, or do you think it has created more like polarization in our society too? I was wondering your thoughts on that.
Those are really good questions. Thank you for those questions. So just one brief reminder, when I'm talking about expressive individualism, I'm talking about the premises of the legal doctrines and principles themselves, okay? I'm not commenting on individuals' self-understanding. Now, Robert Bella's book, Habits of the Heart, identified expressive individualism as a view of self-understanding that was widely shared in American culture, and I'm quite sure that that's true. And I take you to be asking about that question. And it is, I think, in some ways distinctive to American culture because of our emphasis on freedom and independence and individuality and rugged individualism. I'll say also that it has been demonstrated by legal philosophers like Roscoe Pound and others that in American law, across the board, not just public bioethics, there is a kind of emphasis, there's a sort of paradigm of the individual, the radical individual rational decision maker, which drives legal doctrines in property and torts and other different areas of regulatory law, and it is distinct to American law. There's something culturally fertile in our tradition here that makes expressive individualism uniquely appealing and attractive. And if you look at, and according to Bella, if you look at the sort of the anthropological premises of the founders, you look at Locke and others, you find a kind of ontological individualism, Adam Smith, but the ideas there weren't so much, the goal of that kind of individualism was not expression of the authentic individual truths that you have inside yourself, but instead a kind of community of individuals pursuing their own interests, respecting the natural rights of others in a well-regulated system of laws for the sake of the greater good. So that's a different kind of goal of individualism from the founders, according to Bella and others. But something happened culturally in the United States, well, around the world, but especially in the United States, where human flourishing became reoriented. And I give a whole account of this in the book, and Bella talks about it, and McIntyre talks about it elsewhere, that sort of defined flourishing in this sort of expressivism, rather than simply the sort of utilitarian version that might have predated that. But yeah, I do think it's the case that the American context is, and I used to, when I worked for the President's Council on Bioethics, I was I led the U.S. delegation at UNESCO, which is the UN Education, Science, and Culture Organization, to negotiate treaties and declarations with other 191 member states on behalf of the U.S. government on bioethical questions. And what became very clear is the U.S. is the kind of ground zero for an individualistic understanding of law and ethics, and Western Europe is less so. But there are parts of the world where there's the kind of the opposite extreme, where it's purely a collectivism that people think, that they think about flourishing strictly in light of the flourishing of the whole and not so much about individual dignity or freedom. And so there's a wide range of possibilities, but your instinct is correct that the United States is, I think, unique among nations to emphasize individualism as it does, and expressivism sort of came later. If Charles Taylor is right in his intellectual genealogy, sort of the second half of the 20th century is when expressivism kind of becomes the marker of flourishing.
Professor Snead, I was wondering, as I go to other raised hands, could you give a concrete example of like an area, a contemporary issue in American culture or politics, where we really see these the problems, the limits of expressive individualist anthropology come to a head?
Absolutely. In fact, if you look at this slide, I have a concrete analysis, which is one of the chapters in the book, which relates to American abortion jurisprudence. And again, and what I did is I took the law itself, I looked at the jurisprudence from 1973 and Roe v. Wade up until 2020, which was when the book was published. And in the later edition, I have a kind of appendix, an epilogue that talks about the Dobbs case. But basically, the question I asked, I said, okay, I'm just going to read these cases, and I'm going to ask the questions, what do these justices, in their reasoning, what do they think the human person, human identity is, and what human flourishing is? And it turns out the way they derived the unenumerated fundamental right to abortion in Roe v. Wade was precisely through a kind of reflection, first of all, a framing of the human context in which the question of abortion arises, and then describing the goods and burdens and harms at stake through the lens of expressive individualism. And as a result, the reasoning suffered from a kind of myopia that fails to take on board other possible ways of framing the question and other ways of describing the consequences of the situation. So the normative framework in Roe v. Wade, so let me just very briefly, okay, so the court in Roe v. Wade was doing something called substantive due process, which means they took the language from the 14th Amendment, ratified in 1868, which says no person should be deprived of life, liberty, or property without due process of law. Now, when you read that, on its face, it's a procedural provision, right? It says, it doesn't say the government can't take your life, liberty, or property. It says, when the government does take your life, liberty, or property, you are entitled to due process, which most people associate with fairness and procedures associated with fairness. In different contexts, that plays out in different ways. But there was a line of jurisprudence that began, well, really at the beginning of the 20th century in a totally different context of economic regulation, in which the court read into that procedural language certain substantive protections that are not mentioned in the Constitution, but the court says have to be read into the Constitution for the procedural language to be efficacious and to be intelligible. So in the and this is a lot of background, but it's necessary. In the early part of the 20th century, there were a lot of regulations, economic regulations, that were meant to, for example, limit the number of hours that bakers could work, which were in the state of New York. This is a case called Lochner versus New York, where the state of New York says, we think that bakers are being exploited by the bakery owners that they work for, and we're going to limit the number of hours that they can work. And so, but that law was struck down because the Supreme Court in the Lochner case said, well, we think, even though it's not mentioned anywhere in the Constitution, there has to be a fundamental right to engage in contracts between private parties, because that's so essential and fundamental to what it means to be free and to flourish in the United States. It has to be read in because that's so important to human flourishing, this freedom to contract. Now that became one of the most discredited doctrines in early American jurisprudence because there is no right to contract in the Constitution. And what the court was essentially doing was reading it in its own sort of libertarian economic principles into the Constitution because they thought they were really important, right? But over time, the court said no. The court corrected that mistake about 40 years later, corrected that mistake and said, you know what, that's actually not right. We can't, this is an area left better to the political sphere. We can't impose our own normative judgments in this way under the auspices of interpreting a procedural phrase from 1868, okay? Well, fast forward to 1965, the court resurrects this doctrine of substantive due process and starts again to read into the Constitution principles, substantive principles that they think are especially important for the flourishing and success of the American people. And they begin in 1965 in a case called Griswold, and they say, well, there's a right to privacy in the marital context. intimacy between spouses is so important that we're going to read in a right to privacy that includes the right of married couples to use contraception without being regulated by the state. Okay, well, whether one thinks or doesn't think that is a good policy outcome, what the court did in that case was to read in a particular policy good that they thought was especially important and encoded it into the procedural language of the 14th Amendment. Okay, and I think most people didn't object strenuously to that. There weren't massive movements to try to change the composition of the Supreme Court. There weren't marches on Washington because of this. In fact, the Griswold versus Connecticut case in some ways was a setup because it was a kind of collusion between the prosecutors in Connecticut and the ACLU who wanted a test case that could get this to the Supreme Court and get this kind of result. But it wasn't controversial exactly. It was in certain quarters, but not widely controversial. Well, in 1973, the question of abortion comes up, right? And the background facts are in 1868, when the 14th Amendment was ratified, abortion was a crime from the moment of conception almost in every state, okay? Codified by statute. And in those states where it wasn't codified, it was a common law crime, okay? So it was never the case before 1973 that there was deemed to be a right to abortion. But the court was confronted with this case out of Texas involving a law in Texas that banned abortions except in cases where a woman's life is at risk. And the court took the opportunity to think about this question of abortion and whether or not this right to privacy articulated in Griswold should be extended to the context of the right to get an abortion. Now, the normative framing of this case, and this is where the anthropological roots of it come into view, the normative framing of this case, according to Justice Blackmun, was, well, okay, let's describe the human context in which this issue of abortion arises. Who are the players in this human context? Well, there are two strangers. There are two atomized individual strangers that are principally at issue in this case. There is their mother, or the woman, who is pregnant, who is indisputably a person, morally speaking, constitutionally speaking. And then there is this other individual, the unborn child or the fetus, however you want to describe that individual. And that individual, the legal personhood of that individual is in dispute. The constitutional personhood is in dispute, but even the legal personhood is something that the court had a particular view of that conflicted with the view of the various states and other courts too. Historically, the protections of personhood are effectively given to the unborn, but this became an open question. And then the court says, okay, how do we think about this situation? First of all, the cast of characters follow from the script of expressive individualism. Two atomized individuals, not defined by their relationship to one another, in fact, abstracted from that relationship. It's not a relationship of mother and child who are connected not just bodily but biologically in terms of history, in terms of genetics. They are deeply embedded and already in relationship to one another, but the court dissolves that relationship and describes it in the context of radical individualism, okay? And then the court says, the issue here are the competing interests of these two atomized individuals in this space. What are the burdens? What are the burdens at issue in this case? Well, the woman is undoubtedly burdened by the bodily burdens of pregnancy, unwanted pregnancy, although that takes up a very small part of the court's reasoning. The rest of it was the burdens on the woman were the burdens of unplanned parenthood, not unplanned pregnancy. The burdens of raising a child who you don't want or can't take care of. The burdens on the community of an unwanted child. The psychic burdens of having a biological kin in the world that you didn't choose. Those are all the burdens that the court articulates on one side of the ledger in Roe v. Wade and Planned Parenthood v. Casey, and those are undoubtedly burdens, right? Those are real burdens. What's on the other side of the ledger? The other side of the ledger is a being of ontological and moral ambiguity. Why? Implicitly, because what is a person? A person is the kind of being that can formulate future-directed plans. And this is where the court kind of follows the reasoning of the philosophical literature of personhood. Marianne Warren and Michael Tooley and later David Boonin and the arguments of the moral significance of unchosen obligations of Judith Jarvis Thompson, all of which is shot through with expressive individualism and the concepts. And the court says, well, this isn't, not only is the fetus not a person implicitly because the fetus can't do things that a person does, because persons are defined by their will. That's implicit. The court doesn't actually say that. But the fetus isn't even like a part of this conversation. Really, what's part of this, it's the state's interest in what the court then describes as potential life that is on the other side of the ledger. So when you're confronted with a zero-sum conflict of two atomized individuals who are strangers to one another over the goods and resources that properly belong to one of them, the mother or the woman, then the result that you get, first of all, it's a narrative of conflict. The relationship is defined by will and choice. There's no relationship of mother and child until someone makes a decision to be a mother, even though there's a biological relationship between two individuals in that way. And the court says, what do? We have to license one of the two combatants to use lethal force against the other one to resist their intrusion into the interests and body of the first person. Okay? Now, that may be a narrative of human conflict that people agree with or disagree with, but it's not the only way to describe the human context in which the question arises, right? One can also think about this relationship in the context of human embodiment, and to say that if we take seriously the meaning of human embodiment, we don't atomize and artificially separate and abstract the two players involved in this human context and then license one to use power to repel the other one. What we do instead is to take a look and say, what is the meaning, what's the embodied meaning of this relationship? This is a relationship with two beings that already exist in a kind of relationship, a dyadic relationship to one another. It's a relationship of biologically speaking, mother and child. That's the relationship that we're talking about. And what do if you're confronted, if a community, if the law, a decent person is confronted with a crisis involving a mother and child? Well, you might not license the use of force by one against the other because you're not treating them as strangers fighting over scarce property. You're treating them as family members who are suffering from a crisis with real burdens and real problems. And one reaction to that crisis is to rush to the aid of that mother and child and to surround them with the support and care that is needed under those circumstances, and to not just make one parent in that situation honor her unchosen obligations to her child, but every family member has obligations to that child. Everybody in the community has a relationship to that mother and child and that family. Everybody in the country has a relationship to that mother and that child and that family that demands that we stop what we're doing and that we rush to their aid. And a legal framework built on an embodied reality that takes seriously those embodied relationships looks very different from the jurisprudence of Roe and Casey, which instead begin with a narrative of strife and conflict of atomized individual wills. That was a very long-winded answer to your question, but that makes it more concrete than just talking about in the abstract.
Thank you very much. This is really fascinating. I actually could listen to you talk for hours, but the students probably want to go. But actually, my question is really related to what you just said, because I've always been really intrigued by this idea of, as you said, uncalculated cost, or maybe uncalculable cost, because when you said that, it just reminded me again of, I think my parents and certainly my grandparents wouldn't have thought in terms of their relationship with other people in their family or their community as having a calculable cost, right? And one of the problems with this, I mean, now that I'm older and I have my own children, I realize that, first of all, you can't calculate the cost. In fact, if you knew the cost, you'd be terrified, right?
It wouldn't even make sense.
Wouldn't even make sense, right?
Yeah, you'd be like,
but what doesn't come into play is the uncalculated gain. And I was just really, I mean, again, I've been struck by this idea, if you wanted to comment on that, because a lot of times, as you're talking about abortion, for example, all that's figuring in here is the uncalculated cost and the astronomical cost, but that most people who have children, when they look back, they realize, or when they take care of, a dying parent, or they are there for a good friend who's suffering really deeply, they don't regret that. Most people don't regret that.
yeah. So there's so now that Dobbs has sent the question of abortion regulation back to the states, what you have is in each state a battle, either in the legislature or in the courts, about whether or not what the law on abortion should be. Right? So what Dobbs did was send the question back to the political branches. Didn't settle it the way that the court did in Roe and Casey. It said, this is not for us to decide. You guys in the political branches can work this out amongst yourselves. And one of the things that's happening, interestingly, is in courts you have sort of mini Roe v. Wade's vis-a-vis the state constitutions at issues. And I've been working as an expert witness in a lot of these cases. And in Kentucky, for example, there was an argument that the 19th century Constitution of Kentucky actually has a sort of secret right to abortion in it that the court should discern and impose on the state of Kentucky, right? The arguments are exactly what I've been describing. So they have expert witnesses, they have experts on the bodily burdens of pregnancy to say why there has to be a right to abortion because the bodily burdens of pregnancy are so serious. But then the second argument is what you're talking about. That is, nothing is worse for you in your socioeconomic life than having a child, is the argument that they make. They say the worst thing you can possibly do to derail your education attainment, your financial attainment, et cetera, is to have a child. And there's literally an economist from Texas A&M that like lays this all out with charts and says like, and it's especially, and this, well, I won't get into the especially egregious claims that are made because they're so inflammatory. I don't want to get into that right now. But the bottom line is there's this study called the Turnaway Study, which you may have heard of. And the Turnaway Study is a social science study that means to show what happens to women when they're turned away from the abortion clinic, when they're not allowed to get the abortions that they want, okay? And what it shows, actually, is that within 5 years of having a child that they didn't plan for, there are obviously economic consequences to that, right? But what it also shows, which you don't hear much about, is after 5 years, almost all those metrics revert to the norm and revert to people who don't have, who are also single, right? So after 5 years, everything kind of returns to normal. But the most extraordinary thing that you never hear about in the Turnaway Study, and there are a lot of methodological flaws to the Turnaway Study involving how many people they surveyed and whether they kept track of them over time, but of the people that they kept track of, they asked these women who were denied abortions, who wanted abortions, 98% of them said they're glad they didn't get abortions. 98% of them said, with all that problems that were shown in the 5 years following that, 98% of them said, I am so happy that I have this child in the world. And so that is, I think, reflects empirically something that you were alluding to in your remarks. So thank you very much for the question.
Thank you all for coming. Don't forget to head down the hall.